A federal courtroom falls silent. Then pandemonium erupts. U.S. Marshals are dragging Donald Trump's chief legal counsel out of the building. This isn't a reprimand. This isn't a penalty. This is total expulsion. What's unfolding before our eyes transcends ordinary legal warfare. This is the precise instant when American jurisprudence reached its absolute threshold. I'm about to dissect the most incendiary judicial explosion in contemporary legal history, second by second, detail by detail. By the time we're finished, you'll grasp exactly why the entire landscape just transformed. Tap that subscribe button immediately, because what I'm about to expose won't remain concealed much longer. January 17th, 2026, 10:23 a.m. Eastern Standard Time. Eastern Standard. Federal Magistrate Arthur Brennan strides into his chambers wearing an expression that sends chills down veteran litigators' spines. 37 media correspondents, 12 courtroom illustrators, 60 citizens who'd been queuing since dawn just to witness history. Everyone felt it brewing. Something seismic was about to shatter. Brennan dispensed with formalities entirely. He launched straight into a pre-written declaration, his tone glacial, deliberate, devastating. 7 distinct occasions of purported fabrication by Trump's legal squadron, 7 documented instances where they'd allegedly deceived his tribunal. Principal counsel Emil Bove III remained seated, rearranging documents, his gaze fixed anywhere except the judge's bench. He understood what was approaching. Then Magistrate Brennan posed the inquiry that would alter everything. Counselor Bove, I require clarification. Will your defendant adhere to the January 31st discovery submission deadline, affirmative or negative? Straightforward inquiry, correct? Bove attempted evasion. Your Honor, our team has submitted a reconsideration petition that specifically addresses. That fails to constitute a response. Brennan severed his statement like a scalpel through tissue. Affirmative or negative? What transpired next was absolutely staggering. Bove attempted redirection, repeatedly, persistently, relentlessly. 7 instances, 7 consecutive maneuvers to circumvent answering a direct judicial inquiry. 7 instances, Magistrate Brennan reiterated, affirmative or negative. Will you honor this tribunal's directive? The chamber became petrified. Journalists ceased documentation. Security personnel braced themselves at the entrances. Everyone comprehended. This had transcended routine legal posturing. This was a constitutional emergency materializing in real time. Consider the implications for just one moment. We're not discussing some municipal traffic violation. We're discussing a federal magistrate, an individual who's consecrated their entire professional existence to preserving legal order, being compelled to question whether counsel is providing truthful testimony. When judicial officers cannot depend on attorney credibility, the entire infrastructure disintegrates. Every proceeding becomes hazardous. Every declaration becomes questionable. Justice itself becomes unattainable. And that's precisely the precipice where we found ourselves on January 17th. Upon the 7th deflection, Magistrate Brennan positioned his writing instrument down with calculated, ominous exactitude. The quietude within that chamber was asphyxiating. Counselor Bove, he commenced, and you could perceive the gravity in each syllable. I have extended 7 distinct opportunities for you to furnish a straightforward response to a straightforward inquiry. He suspended, allowed it to permeate. Your persistent equivocation compels me to determine that you are either incapable or unwilling to interface with this tribunal in authentic good faith. That terminology, unwilling, it reverberated throughout the space like a verdict of condemnation. Correspondents characterized the instant as viscerally taut. Multiple security officers near the rear portals adjusted their stances, anticipating the inevitable. Then arrived the thermonuclear declaration. Exercising my jurisdiction under Federal Criminal Procedure Regulation 44 and the intrinsic authorities of this tribunal, I am adjudicating you in contempt and mandating your instantaneous expulsion from these proceedings. You are prohibited from manifesting in this courtroom pending further notification. The pigmentation evacuated Bove's complexion. Your Honor, I must register the most vehement possible. Your protestation is documented for the transcript, Brennan interjected, already gesturing toward the security officers. You possess 60 seconds to collect your materials. 60 seconds. Envision receiving 1 minute to dismantle your vocation, your standing, your self-respect, and depart a federal courthouse in humiliation while the entire planet observes. Leave your perspective in the comments immediately if you comprehend the magnitude of what just transpired, because this transcends legal mechanics. This is American democracy inoculating itself against someone who considers themselves exempt from it. But here's what makes this genuinely cataclysmic. This wasn't Magistrate Brennan overreacting to a solitary unfortunate incident. This represented months of systematic conduct, months of evidence violations, abandoned timelines, what prosecutors characterized as calculated impediment through procedural manipulation. Allow me to illustrate the comprehensive landscape. December 4th, the Defense Coalition submits urgent petitions at 11:47 p.m., merely 13 minutes preceding a midnight cutoff. The submissions incorporated what Magistrate Brennan subsequently labeled substantively deceptive characterizations regarding documentary accessibility. Translation: they fabricated claims about whether documentation existed. January 14th, prosecutors deliver a confidential brief chronicling no fewer than 4 occasions where defense assertions to the tribunal directly conflicted with substantiation acquired through autonomous subpoenas. 4 instances, they articulated one narrative. 4 instances, the evidence demonstrated they'd articulated something counterfactual. This is where circumstances become intensely personal for Magistrate Brennan. When he examined those contradictions in his private quarters on the morning of January 17th, informants indicate he instantaneously recognized this wasn't unintentional error. This wasn't misunderstanding. This was premeditated fabrication. And here's the reality about federal magistrates. They don't expel attorneys for employing aggressive advocacy. They don't summon security personnel over standard discovery conflicts. They reach this juncture exclusively when they conclude the integrity of the proceedings themselves faces direct undermining. Exclusively when they comprehend that every utterance from the defense coalition must be independently authenticated because confidence has been thoroughly annihilated. If this is crystallizing clarity for you, activate that appreciation indicator immediately. So what was the documentation that ultimately fractured the foundation? According to legal scholars who've examined the accessible submissions, the defense asserted a particular document was non-existent, categorically denied its existence. Subsequently, subpoenas to external entities revealed it absolutely existed. But here's where circumstances deteriorate catastrophically. This wasn't merely any documentation. This document purportedly encompasses communications that fundamentally contradict sworn declarations in antecedent submissions. Absorb that reality. The defense coalition swore something was accurate under oath, then documentation surfaces demonstrating they knew it was counterfactual. When this materialized, multiple prosecution coalition members exchanged conspicuous expressions. Even they were astounded by how flagrant the contradiction appeared. A retired federal litigator articulated it immaculately to NBC correspondents. This category of contradiction penetrates the essence of judicial proceedings because tribunals fundamentally cannot operate if they cannot depend on attorney characterizations. Contemplate it through this lens. Envision you're constructing a residence. Every measurement the contractor provides is inaccurate. Every substance they claim to utilize is actually something inferior. Every schedule they promise is fabrication. Eventually, you cannot construct anything. The entire undertaking disintegrates. That's the consequence for justice when attorneys fabricate to magistrates. The entire adversarial infrastructure, the cornerstone of American jurisprudence, it completely fractures. And here's what should genuinely horrify anyone who values legal principles. If this conduct transforms into acceptable practice, there's no constraining mechanism remaining. Every litigation becomes a competition of what can we articulate until we're exposed? Every tribunal submission becomes dubious. Every attorney becomes a prospective fabricator. Every magistrate becomes impotent. Is that the America we desire, where the influential can simply fabricate to tribunals without ramifications? Now contemplate the residual defense coalition. They're trapped between 2 incompatible pressures. On one dimension, professional obligation. They must advocate for their defendant vigorously, construct every conceivable argument, present every potential challenge, pursue every pathway that might advantage the defense. That's what the legal profession mandates. On the opposing dimension, a federal magistrate who has publicly announced his fundamental skepticism of their characterizations. Every submission they present from this instant forward will be examined through a prism of distrust. Every declaration they articulate in tribunal will be interrogated. Every assertion they advance will necessitate autonomous authentication. They now must reconstruct trustworthiness that may be unattainable to resurrect. And here's the absolutely merciless component. There's no plausible defense to what transpired. Either scenario A, the documentation genuinely was non-existent when they claimed it was, which would necessitate accepting that a prestigious law corporation conducted an investigation so incompetent that it overlooked communications subsequently discovered by subpoena. Or scenario B, the documentation existed, and they mischaracterized its condition to the tribunal. Those are the exclusive two possibilities: incompetence or fabrication. And Magistrate Brennan has articulated with crystal transparency which one he accepts. Legal and political scholars throughout the ideological spectrum are characterizing this as a transformative juncture. Jonathan Turley, George Washington University jurisprudence professor and prominent conservative legal analyst, informed Fox correspondents that the expulsion constitutes an exceptional action that magistrates reserve for the gravest violations of professional standards. Even Alan Dershowitz, who has advocated for Trump in antecedent proceedings and frequently demonstrates sympathy toward aggressive defense methodologies, conceded on CNN that Magistrate Brennan's tolerance had transparently been tested past reasonable thresholds. Allow me to reiterate that even Dershowitz, who's constructed a profession on defending the contentious, acknowledged this violated boundaries. A former Deputy Attorney General who functioned under both Republican and Democratic governments articulated it flawlessly on MSNBC. When you're expelled from a courtroom for declining to answer whether you'll honor a directive, you've fundamentally acknowledged that the response is negative, but you're anticipating circumventing articulating it explicitly. Contemplate that. The refusal to respond was the response. Quietude was acknowledgement. The instantaneous legal ramifications are catastrophic. Trump's defense coalition must now reconstruct without their principal attorney while simultaneously functioning under expedited timelines they've repeatedly attempted to postpone. Substituting principal counsel mid-proceedings generates tremendous coordination complications. Fresh attorney must assimilate rapidly. Divergent strategic methodologies must be harmonized. Client relationships must be reestablished. And here's the devastating component. The prosecution can now contend that any subsequent postponements are self-imposed. You expelled your own attorney through misconduct transforms into a prosecutorial instrument. But the precedent being established, that's exponentially more significant. Federal magistrates nationwide are observing Magistrate Brennan presently. They're documenting observations. They're witnessing what materializes when someone ultimately articulates sufficient. Multiple informants within the federal judiciary have specified that numerous magistrates have experienced frustration with analogous obstructive methodologies but hesitated to implement dramatic intervention. Now they're witnessing it's achievable. They're witnessing it can be executed. They're witnessing that tribunals still possess authority. If Brennan's interventions are confirmed on appeal or simply not contested effectively, it transmits to the comprehensive judicial community that aggressive counteraction will be endorsed. The barrier might ultimately be fracturing. A recent Quinnipiac survey discovered that 67% of independent constituents accept Trump should honor tribunal directives without reservation. 67%. Now envision what those identical constituents contemplate when they observe his attorney being physically expelled by U.S. security officers for declining to answer whether he'll comply. It amplifies every narrative regarding disrespect for legal process that's been deteriorating Trump's position with pivotal swing constituents. This transcends abstract legal philosophy anymore. This is security officers escorting someone from a structure because they wouldn't answer a straightforward affirmative or negative inquiry. Visual, tangible, irrefutable, and absolutely devastating politically. But Trump's reaction? It exacerbated everything catastrophically. Within hours, he transmitted declarations characterizing Magistrate Brennan as a radical progressive magistrate and a Biden subordinate, who possesses zero respect for presidential immunity or attorney-client confidentiality. He asserted the expulsion was orchestrated by the Justice Department and pledged that this authoritarian magistrate will be addressed when we reclaim the executive office. Examine that final segment again. Will be addressed. A former chief executive menacing a federal magistrate for implementing the law. Allow me to be unambiguous with you. This is the instant we ascertain if American democracy still operates, not in some theoretical civics manual methodology, not in some hypothetical constitutional jurisprudence colloquium, precisely here, precisely now, in Magistrate Brennan's courtroom. Can a tribunal compel adherence from someone who considers themselves transcendent to the law? Can magistrates preserve jurisdiction when defendants decline to acknowledge it? Can justice endure when one party simply won't participate by the regulations? These aren't rhetorical inquiries anymore. They're the inquiries that will determine whether America persists as a nation of statutes or transforms into a nation of dominance. Because here's what this genuinely concerns: fundamental constitutional doctrines. The relationship between tribunals and litigants depends on reciprocal acknowledgement of judicial jurisdiction. Even the most influential litigants must acknowledge that when a magistrate poses an inquiry, you respond to it. When attorneys decline to respond to direct inquiries from magistrates, they're not merely being evasive. They're contesting the fundamental premise that tribunals possess the authority to compel truthful responses. If that premise collapses, the entire edifice of American justice transforms into merely consultative. Tribunals transform into recommendations. Magistrates transform into suggestions. Law transforms into discretionary. And once law transforms into discretionary for the influential, it transforms into insignificant for everyone. This scenario has generated absolute panic within Trump's comprehensive legal network. Intelligence indicates that attorneys throughout his various litigations convened urgent conference communications within hours of the expulsion. Some advocated for intensification, submitting instantaneous appeals, contesting Brennan's jurisdiction, denouncing the expulsion as judicial excess, initiating warfare with the entire federal judiciary. Others purportedly recommended a comprehensive transformation in methodology, cautioning that sustained confrontation jeopardizes alienating magistrates throughout multiple jurisdictions simultaneously. They're petrified because they comprehend something critical. Every magistrate in every Trump litigation is observing how their colleague is being characterized. Every declaration characterizing magistrates as corrupt or politically manipulated can be referenced in subsequent proceedings as substantiation of disrespect for judicial jurisdiction. The denouncements aren't merely ineffective, they're actively detrimental. If you're still engaged, activate that appreciation indicator because it genuinely facilitates this reaching additional individuals who require comprehending what's at stake. Meanwhile, Trump's most vociferous advocates are absolutely incensed. Social platforms are saturated with assertions that Brennan is a clandestine state operative, that the expulsion demonstrates the infrastructure is manipulated, that no legitimate magistrate would ever implement such intervention against a former chief executive's attorney. To the foundation, this constitutes additional substantiation of the weaponization of justice they've perpetually asserted exists. But here's the merciless reality they're overlooking. The substantiation is accessible. The transcripts are obtainable. The configuration of evasion is chronicled. This wasn't a magistrate experiencing an unfortunate incident. This wasn't political persecution. This wasn't clandestine state conspiracy. This was an attorney declining to respond to a direct inquiry, 7 consecutive instances. That's not interpretation, that's not perspective, that's chronicled actuality. When your defense to a contempt determination is denouncing the magistrate's politics rather than clarifying your conduct, you've conceded the substantive argument. You've acknowledged you don't possess a defense. You've confessed that the exclusive remaining option is deflection and personal denunciation. This transcends a solitary courtroom confrontation. It concerns whether any tribunal can effectively implement jurisdiction over this particular defendant. If Trump can characterize every adverse adjudication as persecution, every magistrate who adjudicates against him as corrupt, every directive he opposes as illegitimate, then the legal infrastructure possesses no mechanism for accountability. Once that precedent is established, the rule of law signifies nothing for anyone with adequate public platform to delegitimize magistrates. Contemplate that future for an instant. Any politician with adequate followers can simply decline tribunal directives. Any defendant with adequate media accessibility can denounce magistrates until they capitulate. Any influential individual can transform their prosecution into a public relations initiative rather than a legal proceeding. Is that justice? Or is that merely dominance? Here's where circumstances currently exist. A federal magistrate has expelled a former chief executive's principal attorney for contempt, announcing from the bench that he cannot depend on the defense coalition's characterizations. The residual attorneys must now navigate proceedings beneath a cloud of judicial skepticism, while their defendant publicly denounces the magistrate as a political operative. Magistrate Brennan has scheduled a session for January 24th to address how proceedings will advance with restructured defense counsel. Multiple legal coalitions are purportedly preparing urgent appeals contesting the expulsion. Courtroom observers throughout the federal judiciary are observing meticulously to ascertain whether one magistrate's determination to ultimately articulate sufficient transforms into a prototype for others confronting analogous methodologies. This transcends merely another information cycle that will dissipate. This is the American legal infrastructure testing whether its jurisdiction possesses any significance when confronted by a defendant who declines to acknowledge it. The substantiation is accessible. The expulsion has transpired. The contempt is documented. Now we anticipate to ascertain if accountability still possesses any significance in a courtroom where the defendant considers himself transcendent to the very process designed to adjudicate him. Before I release you, I require you to comprehend something. What transpired in Magistrate Brennan's courtroom on January 17th wasn't exclusively about Donald Trump. It wasn't exclusively about one attorney or one litigation or one magistrate. It concerned whether American tribunals can operate when a defendant simply declines to participate by the regulations. It concerned whether federal magistrates can preserve jurisdiction confronting coordinated impediment. It concerned whether equal justice under law, those words inscribed above the Supreme Tribunal, still signify anything. And the response we acquire in the approaching weeks will determine the trajectory of American democracy itself. That's not exaggeration. That's not amplification. That's the transparent reality of where we exist. So I'm requesting you activate that subscribe indicator immediately. Activate that appreciation indicator. Disseminate this content with everyone who requires comprehending what just transpired, because the stakes have never been more elevated. The confrontation has never been more unambiguous. And the inquiry of whether America persists as a nation of statutes has never demanded a more instantaneous response. Maintain your observation on this narrative. Maintain your observation on Magistrate Brennan's courtroom. Maintain your observation on whether justice can endure when dominance declines to submit to it. The subsequent chapter is being inscribed immediately, and we're all witnesses to whether it concludes with the rule of law or the law of rulers.